Chapter 61. Bigamy or Polygamy. Section 770. Definition and History. The crime of bigamy or polygamy consists in marrying one person when already legally married to another. In earliest times bigamy was an ecclesiastical offense, but by statute, James I, chapter 11, it was made a felony. In our states the offense is statutory, though one early decision holds it a common law misdemeanor. Section 771. Elements of offense. The gist of the offense is a marriage, while there is in existence a valid prior marriage undissolved by death of the other spouse, presumption of death or divorce, with criminal intent. Each of these elements, the second marriage, the valid prior marriage, and the intent to do an act prohibited by law, must concur to support conviction. Bigamous cohabitation is not an element of the crime, but statutes frequently punish this as a separate offense, and cohabitation under the second marriage may be punished as adultery. Section 772. Jurisdiction. The prosecution must be where the crime, that is, the second marriage, was committed, and one cannot be prosecuted in one state for a bigamous marriage entered into in another. But under a statute which punishes bigamous cohabitation, it does not matter whether the second marriage was contracted in the state, and there are also statutes punishing the leaving of the state with intent to contract a bigamous marriage, which intent is carried out. Section 773. Valid prior marriage. A valid prior marriage is an essential element of the crime, a part of the corpus delicti, and usually the part with which the evidence is most concerned and over which questions of law most frequently arise. It is necessary, unless common law marriages are recognized, to show that the parties declared before some authorized person, that they took each other for man and wife, and it is immaterial whether they afterward cohabited, or had sexual intercourse. The law of the place where the marriage took place determines its validity. Proof that the parties lived together and held themselves out as husband and wife and had children born to them is sufficient in some states, and insufficient in others. It is usually sufficient to show a marriage prima facie valid, where residents of a state whose marriage would be illegal, are married in another state. That fact alone does not render the marriage illegal in the state of their residence, so that a subsequent marriage there is not bigamous. Where statutes prescribing the form of marriage merely impose punishment for non-compliance with the form and do not make the marriage illegal, a second marriage by one of the parties is bigamy. The prior marriage must be proved beyond a reasonable doubt in a prosecution for bigamy, and the presumption in favor of marriage and the legitimacy of children, which arises when the question concerns the distribution of an estate, is very much weakened and overcome by conflicting presumptions, among them that of innocence, and of the validity of the second marriage. Section 774. Voidable prior marriage. It is no defense that the prior marriage was voidable, if it had not been avoided prior to the second marriage, for a voidable marriage subsists until avoided. So if one of the parties was under the age of consent and has not avoided the marriage, a subsequent marriage by the other party is bigamous. If the party under age subsequently marries before the former marriage became binding, such subsequent marriage annuls the former and is not bigamous. And where a marriage by parties under age of consent is made valid only when they cohabit after becoming of age, a second marriage is not bigamous unless such cohabitation is shown. If a marriage ceremony performed without license or with a void license is followed by cohabitation, it is so far validated, as to form a foundation for a bigamy prosecution. Nor is fraud in the previous marriage a good defense to the charge of bigamy, if the parties later lived together as husband and wife. Section 775. Void previous marriage. It is a complete defense to a charge of bigamy that the prior marriage was absolutely void. So where a statute makes void a marriage with a deceased wife's sister, a subsequent marriage is not bigamous. If the ceremony is performed without license or proper ceremonies and is not followed by cohabitation, then a subsequent marriage by one of the parties is not bigamous. So where one contracts a bigamous second marriage, and subsequently the first marriage is dissolved by death or divorce, and he marries a third time, the third marriage is not bigamous, since the second one was void. If the second wife was recognized after the termination of the first marriage, then in some jurisdictions he could be convicted of bigamy in a third marriage. In many jurisdictions a consensual marriage is held invalid, and proof of such marriage will not support a conviction of bigamy. Mistaken believing a prior marriage invalid is a mistake of law and not a defense. Section 776. Divorce from first marriage. If the prior marriage was terminated prior to the date of the second by a divorce which in the state of the former would entitle the defendant to remarry, the second marriage is not bigamous. Generally speaking, a divorce valid as to one of the parties terminates the marriage as to the other and should be recognized everywhere. But if one is indicted in one state for marrying a second time in that state and his first wife is alive, it is not a defense that he was divorced from her in another state unless such divorce is valid in the state of the former. Where a statute prohibits the party for whose fault the divorce was granted from marrying again, his second marriage in that state will not be bigamous unless so declared by statute. Nor is it bigamy for him to remarry in another state unless he does so merely to avoid the laws of the state in which he resides. If a divorce decree is invalid for want of jurisdiction of the court which rendered it, it is no defense to a charge of bigamy. According to the weight of authority, the fact that one believed in good faith he had been lawfully divorced from his first wife, when in fact he had not, is no defense. The statute requires persons who have been married to know that the first marriage has been terminated before entering into another. A divorce from the first marriage obtained after the second marriage is no defense. Section 777. Death of former spouse. Proof and presumptions. Most statutes exempt from prosecution for bigamy a marriage where the first spouse has been absent 7 years and the other has no knowledge of the absent one being alive during that time. This exception is a part of the common law. The prosecution must therefore prove that the first spouse was alive at the time of the second marriage. If the proof shows such spouse alive within less than 7 years before the second marriage, then the question becomes one of fact for the jury and there may be presumptions of fact which will overcome that of continuance of life, as where when last heard of the spouse was mortally ill, and the intervening time has been such that the presumption of innocence may prevail. After 7 years' absence the prosecution must prove not only that the first spouse was alive within that period, but that the defendant had knowledge of that fact. Continuous absence for the statutory period without knowledge on the part of the other spouse, is a complete defense. An honest belief in the death of the other party has often been held not a defense, but some cases hold that it is, if based on reasonable grounds. Section 778. Proof of marriage or divorce. We have stated that in a bigamy prosecution marriage must be proved beyond a reasonable doubt. In many jurisdictions this must be done by direct evidence. In some jurisdictions proof of cohabitation and a holding out as husband and wife is sufficient. An official certificate of the record is usually sufficient evidence, with identification of the parties. Marriage may also be proved by the testimony of a witness present at the ceremony, and the one who performed the ceremony or the party to the bigamous marriage may testify. It seems to be the present controlling rule that proof of a marriage in fact in another state, followed by cohabitation, is sufficient, without further proof as to its validity. Admissions of the defendant as to the prior marriage, made during cohabitation under such marriage, have been held sufficient evidence of its validity. Registry is the best evidence of a foreign marriage, but testimony of witnesses may be enough, or even proof by cohabitation and recognition, by admissions and conduct, where consensual marriages are recognized, but some courts do not recognize this as sufficient proof. Divorce should be proved by the record. Section 779. Second marriage. The attempted second marriage may be in any form or by any words which would constitute a good marriage, except for the bar of the first marriage. A common law agreement followed by cohabitation may be sufficient in some states. Since the offense consists in appearing to contract a second marriage and thus bringing the other party into marital intercourse, it is not a defense that the second marriage would have been void or voidable on other grounds than bigamy, as where it was fraudulently performed, or the parties were within prohibited degrees of kin, or that the marriage was one between a negro and a white, prohibited by law, or it would have been voidable for a technical defect. But the ceremony may be so imperfect, that if not followed by cohabitation, it will not sustain a conviction. Section 780. Intent. A guilty intent is an element of the crime, but an intent to do an act prohibited by law is sufficient, and a religious belief that polygamy is proper is not a defense. A mistake of law is not a defense, as we have seen, since an honest belief in the invalidity of a former marriage, or in the validity of a divorce, does not avail a defendant. It has been held that a bona fide belief that the other party procured a divorce in another state, is a mistake of fact and a defense. English courts hold that a mistaken belief in the death of the first spouse, based on reasonable grounds, is a defense, as this is a mistake of fact. Most United States courts are inclined to hold one guilty in such a case, and intent immaterial as in police wrongs. It is said that the consequences to society and the innocent party are so injurious that the law requires positive evidence of death before one contracts a second marriage. Mistaken belief, however, may mitigate the punishment. Section 781. Other defenses. Actual duress is a defense, but it is not duress that one who seduced a girl married her to escape prosecution. The statute of limitations begins to run from the date of the second marriage unless bigamous cohabitation is made a crime. Insanity may be a defense. Section 782, Polygamy. At common law the offense now called bigamy was first known as polygamy. Today the terms are practically interchangeable. Congress passed in 1882 the Edmunds Act, which punishes not only marrying more than one woman, but also cohabiting with more than one woman and holding them out as wives, creating a continuous offense.